Honors, if the court please, we've been informed, Mr. Callahan and myself, that our 15 minutes is to be split, so we have 7.5 minutes each. Because Mr. Callahan and I have agreed, if the court permits, that I'll go first concerning Adam Syed's case, mainly because that provides a chronological background for then Mr. Callahan's presentation. The court will permit.
Sure. The case this morning again is Syed versus Azeem Syed and Adam Syed. Each party will have 15 minutes to argue. You guys agreed to it. You said gentlemen have agreed to split the time. You just reserve any time, or you can use it all in your reserves.
At 7.5 minutes, Judge, I doubt that I'll be reserving any time.
Okay. All right.
One request, if I can I have a 30-second warning, if someone can accomplish that? Good morning, Your Honors. I'm Kerry O'Brien. I represent Adam Syed. Adam Syed is the son of Azeem Syed, the other co-defendant in this case. Specifically, Mr. Adam Syed was charged with 12 counts of having a casino gaming operation on Route 18 in Medina County, and 8 counts of having criminal tools, specifically illegal slot machines. I want the court to be aware of this very specifically, that there were 2 locations, one on Route 18 in Medina County, near the 71 intersection, and the second place, well, a place called Cyber 777, was on Pearl Road or Route 42 going north of the Medina Square. There's a little strip mall there, and it's actually inside, I think, the Brunswick city limits. What happened was, on or about June 4th, 2013, there was a raid on those 2 places by law enforcement officers of Medina County. They confiscated a multitude of machinery from both locations, and simultaneously they also conducted a raid on Azeem Syed's property on Triplet Boulevard in Summit County. That property is known as A&A Vending. In addition, there was a raid to a little storehouse that is right next to A&A Vending, also on Triplet Boulevard. Specifically, Your Honor, it is Adam Syed's contention that the state of Ohio failed to prove, number one, that there was a casino gaming operation going on at either location. Secondly, it is our contention that because the state also failed to prove that these machines were illegal slot machines, therefore, not only are they not contraband, he cannot be found guilty of possessing criminal tools. Now, what we're trying to say is, Your Honors, is that there is a failure of proof, a sufficiency of proof, on the first assignment of error. I'm going to concentrate on the first assignment of error and the third assignment of error, which is the forfeiture assignment. I'm going to skip over the second assignment of error, which is the manifest weight. The statute says that Mr. Adam Syed is accused of purposefully conducting or operating a casino gaming operation at both locations. And he knowingly possessed these criminal tools, i.e. the slot machines. Mr. Syed contracted with a person by the name of Brian Hastings. Brian Hastings has his operation out of Barberton, Ohio. He operates a company called 0 and 1. 0 and 1 is the binary language that Mr. Hastings modified into all the machines, whether they at the Route 18 location or at the Brunswick location. And by modifying these machines, he took them out of the game of chance, which is a slot machine, into a finite sweepstakes that by statute is not prohibited. Mr. Syed paid Mr. Hastings, and it's in the transcript, approximately $10,000 to modify every single machine. Now, it's also important to note that the state had, actually they had one witness, and then they got somebody, Mr. Buxton, at the 11th hour, 59th minute, to also testify as a supposed expert. Mr. Fleener, who was the initial expert for the state of Ohio, testified that of the 60 or 70 machines that were seized, he only tested 2. And the 2 that he tested were the ones that were at the Route 18 location. He never tested any machine at the Brunswick location. Mr. Fleener went on to concede in cross-examination that some of the machines, or all of the machines, that he did not test may have been modified. The other question was, Mr. Fleener said that the hash marks on the 2 machines that he testified that he looked at had not been moved. Mr. Hastings, the defense expert, testified, he was one of the 2 experts that the defense had. Mr. Hastings testified that his modifications, and there were 3 types, they don't necessarily move the hash marks in those machines. Mr. Fleener and then Mr. Buxton testified for the state, saying that that's possible. There could have been a partition of the modification that allowed these machines to become legal, or what they call sweepstakes internet machines. With this idea of the statute requiring a purposeful intent, if you paid $10,000 to an expert to modify every single machine, and that was the testimony from both Mr. Syed and Mr. Hastings, then how can a person be convicted of trying to avoid or evade the statute and its elements? Knowingly possess criminal tools. If you modify these machines to a legal machine, how can you possess criminal tools? With respect to the second issue, actually assignment of error number 3, which deals with the forfeiture provisions, the state seized approximately 60 or 70 machines from those 2 locations. From the A&A vending, I'm sorry, Your Honor. Oh, okay. From the A&A vending, they seized 20 machines still in the shrink wrap. They'd just been drop shipped there. They hadn't even made it to either location. There's 2 seizures of cash. The $3,900 was seized from Mr. Ayed's car in his driveway at his house, nowhere even near these 2 locations. There's $18,000 that the court ordered returned in the journal entry. It's never been returned. I'm asking that all the machines be returned to Mr. Syed, he be found not guilty, and that the money be returned that was ordered, and the $3,900 also be returned, because it's nowhere, there's no proof at all that it was part of a gentleman's club money that he operated in Portage County. Thank you, Your Honors.
Good morning again, Your Honors. May it please the Court. First, let me add in support of Mr. O'Brien's argument that if, in fact, this Court finds that no crime was committed, then it renders the arguments that I have made in my brief in reference to Azeem Syed moot, because Mr. Azeem Syed is charged as a complicitor, and while it is true that you can be found guilty of complicity to a crime if somebody else has not been convicted of it, you still have to somebody has to have committed a crime. And if no crime is committed by Adam Syed, then certainly Azeem Syed could not be complicit in those arguments or in those offenses. I'm going to just, there's too many issues here to talk about in 7.5 minutes. What I'm going to talk about briefly is this. There is no criminal intent. There is no evidence from the transcript of any criminal intent on any activities on behalf of Azeem Syed. The best example I can give this court is if my son asked me to borrow $10,000 for a business venture, and I gave it to him, and he went out and bought $10,000 worth of cocaine and tried to sell it and got caught, would I be guilty of complicity to trafficking in cocaine? Only if I knew or had a criminal intent to commit that offense in providing that aid and comfort to my son. If I was just handing my son something to help him out, and I had no idea that a crime was being committed, or no intention to be involved, or no criminal intent, no criminal mens rea, I should not have been found guilty, and that's the case here. There is no evidence from the record whatsoever that there was any criminal intent on behalf of Azeem Syed. I would also point to the court the offense dates in the indictment that I argued in my Rule 29 motion, and I've argued in this. 4 of the 5 offense dates that Mr. Azeem Syed was found guilty of, Adam Syed was not charged. I believe that the state argues, and perhaps correctly, that you do not need to have convicted a co-defendant or a co-conspirator to be convicted as a co-conspirator. However, I would argue for the court, there must at least be allegations that some co-conspirator committed a crime on that day. That section is there to protect the state when something goes awry at a jury trial and somebody is acquitted. This is not the case. This is a case where there was no allegations or charges whatsoever on the first 4 offense dates of any crime being charged. The 5th date, June 4th, was the date the search warrant was executed in Summit County, Ohio at A&A Vending, owned by Azeem Syed. Upon cross-examination of the state's witnesses, they readily admitted that no matches of serial numbers, no identification was made whatsoever of any of the machines found in Summit County at A&A Vending with the machines in the 2 places in question in Medina County. There's just, I understand the state's argument on venue, but I think there has to be, again, some criminal activity and criminal intent on behalf of the person they intend to convict. In this case, Azeem Syed, before you can get them into your place, into your county, into your venue. Finally, the forfeiture specifications. Azeem Syed was found guilty of all the forfeiture specifications when only 2 of them, 2 and 3, had anything to do with him whatsoever, and that's what this case was all about, Your Honor. Because there was over $200,000 taken, $125 from the house and $100 and change from the business. And I would ask the court to look at the transcripts or pay attention to the transcript. That money taken from the business were bags and bags of change in addition to bills. On cross-examination, the detectives and everybody were asked, any of these machines take change? No, they did not. It is obvious that this was about a money grab and an attempt to bring Azeem Syed in so they could forfeit his money. I would ask the court to pay strong attention to that, and I think when you've done that, I'd ask you to find Azeem Syed not guilty as a matter of law in order that the forfeitures be dismissed and his money and his personal items be returned to him. Thank you.
morning, Your Honors. May it please the Court, my name is Vince Vellucci. I'm with the Medina County Prosecutor's Office for the Appellate State of Ohio. I'll start with Adam's claim, and the first couple assignments of error, the sufficiency and manifest weight. First, I would initially, I guess, note that the mens rea for the illegal gaming law is purposely or knowingly. It's a little bit strange, but it's actually knowingly, so purposely did not have to be proven by the state. There was never any question that Adam Syed owned and operated Cyber City in Medina on Route 18 and Cyber 777 in Brunswick. He admitted that at trial. He admitted he didn't have the proper licensing to conduct a casino gaming operation. So the questions at trial really were these actually some kind of internet cafe, and were the modifications that were allegedly made to these machines, did they take them out of Ohio's definition of a slot machine? Well, the resounding answer, based on voluminous evidence presented by the state, was that these were illegal gaming establishments. These were not internet cafes at all. And any modifications that were made did not take the machines out of the statute. As I said, the state presented multiple witnesses. They all had different connections to the case, and they all said the exact same thing. You had former employees, you had former customers, you had multiple undercover police officers who went in and played these slots.
Of course, you had testimony of Mr. Hastings that he modified the machines, yet there were only 2 machines tested, correct? From one location.
Correct.
Is that a problem for the state? Just bootstrap the rest of the machines? I mean, I don't know if those were modified or not.
No, I don't think it's a problem. I think Syed even concedes, I think, in his brief, that there's no case law requiring the state of Ohio to test every single machine that it seizes in order to determine whether they are all slot machines. He actually only cites a drug case that came out of this court, which is Garnett, which actually supports the state's argument, if you look at it. In that case, this court actually said there was sufficient evidence to find that all 49 pills involved in that case contained oxycodone, despite the fact that the state had only tested a few of the pills. This court held that a random sampling from a bulk quantity is sufficient, and that same logic would apply here.
Except for there was no testing at the one location. Isn't that, don't you think that's important?
Well, I think the fact
you
that...
have 2 drugs taken from 2 different locations.
Well, I think the fact that both contain basically the same slot machines that everybody testified, multiple witnesses testified, operated the exact same way, as pure games of chance, Las Vegas style slot machines, owned by the same guy, same MO, even the same employees, frankly. I think 1 or 2 worked at both locations. It was basically a carbon copy of each other, one in Medina, one in Brunswick. I really don't think that is a big deal in terms of, I think you really look at them as
I don't want to eat up too much of your time, but
sure.
But if you don't test them, how can you tell if they're the same type of machine? I mean, they may look the same, but we're talking about changes within the interior of these machines, aren't we? The modifications that Mr. Hastings allegedly made.
Well, and I would like to talk about Mr. Hastings also, and how unreliable his testimony was. The claim about modification is almost basically solely based on Hastings' testimony, who admits that he has no license, no certifications, no education, no degree in any field that would give him any knowledge on modifying slot machines. What Hastings admitted he does have is his 2 felony convictions at trial. He admitted that when he made the modifications to these slots, he did not know Ohio's definition of a slot machine. I think that's pretty telling, and he even did a report to that effect. He testified that he thought if he removed the machine's ability to pay out directly, the machine might not be a slot machine. Now that's crucial, because that's what he thought he was doing to make it not a slot machine. And we know that these machines were not, you put money into them, but you couldn't get money out of them. when you won, and multiple witnesses testified to this, all the people I mentioned, they all testified. So when you won, you had to actually raise your hand at the end and say, hey, I'd like to get my winnings. And then an employee would come over and pay the winners from the cash register and hand them the money from the register. The machines didn't pay out. Now, if you look at the Ohio law, the definition of slot machines, that matters not in the least how you're actually paid out. It actually says, if it's paid out directly from the machine or in any other manner. That's actually the language. That's what it says. So that could not be more clear. In terms of the internet, all of these people testified, undercover police officers, customers, employees, they testified that neither of these locations, Cyber City, Cyber 77, ever offered the internet to customers. They never did. And customers never used the internet while they were at these locations. In fact, Adam Syed himself admits at trial that he says 99% of his customers never used the internet and came exclusively to play the slots. So what they did do is they put money directly into the slots, like I said, played a game of pure chance, and raised their hand when they were ready to be cashed out. And just back on Hastings, he testifies that he received $10,000 in cash for his work. He wasn't able to provide any invoice or documentation for his work that actually shows exactly what he did, other than, I guess, his word. He didn't even get the terminology right in his testimony. And frankly, I heard it again today, the term hash mark, which is incorrect. The term is actually hash value, and the state presented an expert to that effect that said hash value is the term, and hash mark is not a term that's even used in computer science. So that just again shows Mr. Hastings as an unreliable witness. And by the way, the state's expert, Mr. Fleener, testified that the hash value had not changed. I think Mr. O'Brien mentioned that as well. So, and just in terms of the expert testimony period, and I'd like to just kind of distinguish this Rocco case that was cited by Mr. Syed. That's a 5th District case. It's not binding on this court, but in that case, the problem the court had was that there was no expert testimony whatsoever presented about whether these were slot machines or not. But even that case didn't say that expert testimony is a prerequisite to proving this case. There's no case law that says that the state had to have expert testimony at all, saying that these were slot machines. So when you talk about only 2 machines were tested out of however many, the state really wasn't required to have an expert test any of them. Just the voluminous lay witness testimony would have been enough for the state to sustain its case. So I think you have to look at that too. In terms of the forfeiture, I think the standard of review is very important here. Preponderance of the evidence at the trial level, and this court just has to find some competent, credible evidence for that. In terms of the almost $4,000 that was seized from a rental car at Adam's home, he claims this was a bag of cash from a gentleman's club. However, he admits he had a bank account for that club, but didn't put the money in there for some reason. What they did find was an almost identical bag of cash inside the house that Syed admitted was from Cyber City, his Medina gambling location. The other 2 were 11 and 13. Those were the slots that were seized from the A&A vending business. That's Azeem Syed's business. Basically, the argument there, it appears to me, is the fact that they're not functional. Some of these machines were not functional. Now, there was no evidence presented on exactly which machines were functional and which ones weren't by Adam or Azeem, really, to refute the state's case. And even if they weren't, I think they're still contraband, but they're also instrumentalities, because there's testimony, actually Adam admits that some of those machines were used to repair other machines. So it's still propping up this illegal casino gaming business by allowing non-functioning machines to be repaired by using these machines. It's really which ones were functional, which ones weren't, I think would be based on Adam's self-serving statement alone. And what about a machine that does not need to actually be repaired, but just needs to be maintained? There's no question that's still a slot machine, obviously. So there was certainly competent, credible evidence on those three. Now Azeem doesn't have the right to challenge any of the forfeitures at all, because he actually stipulated at the trial, in the forfeiture phase, that he did not have any rights, title, or interest in any of the property listed in the forfeiture specs, except for the first one. And even on that one, he actually won on most of it. The trial court ordered $104,000 of that to be returned. The trial court agreed with him. Only about $24,000 of specification 1 ended up being forfeited. And Azeem stipulated to that. So he can't argue about that now. This was the cash that was found in Azeem's bedroom closet that Adam had testified was from Cyber City. Right there in his own bedroom. So on that ground alone, Azeem's forfeiture claims have got to be overruled. But you'll see in my brief, there's multiple connections to Azeem to support these forfeiture specs, even if he didn't lack standing, which he clearly does. Just in terms of the connections overall, in terms of the sufficiency of the Azeem complicity counts, there was quite a bit of testimony at trial that connected Azeem to his son's operations, showed that he did aid and abet, knowingly aid and abet his son. Adam admitted that Azeem co-signed the lease for the Brunswick location, the Cyber 777, and that lease itself was actually found in Azeem's business in Akron here at A&A Vending when the search warrant was executed. In fact, there were multiple invoices and other documents that related to Adam's gaming businesses that were found in Azeem's office. There was even one found in his nightstand next to his bed in his house. That's what one of the counts was based on. So the dates of these counts, I know Mr. Callahan mentioned, these are not arbitrary dates by any stretch. You'll see when you look at the record and certainly my brief, I lay out, these are based on dates of invoices, very incriminating invoices that show his business, that show Azeem's business, A&A Vending, actually ordering slot machines, paying for slot machines, having these slot machines delivered to his physical locations on Triplet Avenue here in Akron.
Does that assume that he knew the slot machines were illegal? I mean, the machines were illegal. I won't call them. Does that assume that he knew these machines that were coming to his business were illegal? And was there evidence that he knew they were illegal?
Well, I think if you look at all the circumstantial evidence, absolutely. He never testifies in his own defense at the trial phase. He did testify at the forfeiture phase. Now, so when we talk about manifest weight, from Azeem, there's really nothing to weigh. There really is only the state's evidence, which shows all of these machines were found there. They were not properly modified, like I said, in a way that takes them out of the statute.
What I'm thinking, if there's boxes delivered, and these machines are in boxes, he may not. I mean, he was never at any of the locations when the undercover agents were there, was he?
No. And that's one of the arguments, certainly, is that the jurisdictional argument that he never set foot in Medina County. That does not matter legally in the least. As long as the principal offenses were committed in Medina County. And then there's it doesn't matter if Adam was convicted either. It doesn't matter at all. 292303 talks about it does not matter if the underlying, if you're convicted of the underlying crime. Adam testified that Azeem allowed him to deliver these slots, so he knew about it. They weren't going there without his knowledge. I mentioned there's cash being stored from the Cyber City location in his closet. If he thought that was legal, why would you not put it in a bank account somewhere? Or he's clearly hiding it. This is the kind of
the
circumstance.
money room in the business? Is that what you're referring to?
No, there was cash found there too, but I'm talking about there was also cash found in his bedroom closet,
Oh,
a good amount.
Attorney Delucci, you're out of time.
Okay, well, thank you, and I would just ask that this court affirm the judgment of the trial court. Thank you.
Thank you, gentlemen. You still have about a minute and 20 seconds left if you'd like to use it.
Okay. With respect to the forfeiture provisions, which is assignment 3, the $3,940 that was seized was found in Mr. Adam Syed's car at his residence in Fairlawn. There was no notation, there was no paperwork in the bag that money was found in that indicated that it was part of Cyber City on Route 18 or Cyber 777 out in Brunswick. The $18,000 that was in a Wells Fargo account was ordered returned by the court, but for a reason that, and possibly because the issue was on appeal, it hasn't been returned yet. So we're asking that those sums be returned to Adam Syed. In terms of the issue of whether or not it was an internet cafe or a gambling casino place, once again, I would go back to the idea of the statute which says you have to purposely do something. That's why Mr. Hastings was hired and paid that significant amount of money to modify all the machines. There was no testimony from the state that the other 68 machines were illegal. Thank you.
Thank you both for your presentations today. The court will be taking matter of advisement, issue a written decision, which will be on both sides as well as posted to our website and the Supreme Court.
Thank you.
Thank you.